we have finished our brief overview of what services county behavioral health provides and how those are funded and what the framework is for their provision. So when we're transitioning into the part of the webinar where we're talking about strategizing about how to effectively partner between the criminal justice and behavioral health sides. And so we wanted to start by acknowledging what some of the challenges are in that partnership. And so here's Tracy McCouga talking about one of the challenges.
There's a lot of acrimony and a lot of finger pointing and a lot of, we all recognize there's a problem and it's a deep problem, that only these problems can be fixed by money and only these problems can be fixed by some other agency. And so really one of the strongest initiatives that was supported by the CEO and that was led by Alice and I think myself jointly was to put together an informal group to really start talking about these things in real time and not just from policy perspectives and okay, well, how can we get more money to do this? Let's talk about the person who's just been arrested, who is in the jail for those first 48 hours, and what can we do to assist them when they're in a mental health crisis.
And so Tracy really highlights something that we heard over and over again in the interviews, which is rather than focusing on high-level policy and trying to fix every part of the system as a starting point, start with an individual or a specific problem, work on that, solve on that, and then build on those successes. So the other challenge when you're partnering between criminal justice and behavioral health is that these are sometimes very different cultures. And so Dr. Hobson talked about that culture clash.
And I think this exists in most places. There are two different cultures. We're a culture of healing and rehabilitation being merged with a culture of, I don't want to say discipline, but paramilitary-like structure, right? So it's not all about the touchy-feely and, hey, let's work towards recovery. So those two cultures sometimes clash, and so and I don't think that's just isolated to rural communities. I think that's everywhere. But we're all part of the treatment team, and just making that paradigm shift that we are all part of the treatment team. The correctional officers, the jail medical, us, we're all one. We have to work together.
And this was Chief Jenkins's perspective on the same issue.
Definitely come from different disciplines. We come from different backgrounds. We come from different trainings, and we think we come from different missions. I actually don't think we do come from different missions, but we think we do. And so we have to spend some time working on that to kind of figure out we're actually trying to do the same thing. And what that is we're trying to change behavior of some targeted individuals so that they don't repeat behaviors that have been harmful to them.
So the next challenge that we heard, and I think is important to be mindful of, is the need to develop a shared language and shared vocabulary. Both the criminal justice and county behavioral health worlds or public health worlds are what we might describe as AIEs, acronym-intensive environments. And so we'd really suggest that people not use acronyms and also make sure that when you're using even simple terms that you're both using them the same way. So Chief Jenkins talked about how when he started engaging with treatment, they realized that when probation said risk, they meant risk to recidivate, to end up back in jail. And when the treatment provider said risk, they were thinking about risk of violence. And those are related but different concepts. And so figuring out that they meant different things when they said the same word and then developing a shared vocabulary was really central to an effective partnership. And so Chief Jenkins developed multidisciplinary trainings with both his agency of probation and then the treatment providers, and that's how that can look in a large county like San Diego. But you can scale that up and scale it down, and Dr. Hobson talked about how it looks in Plumas County, where he really has just one county behavioral health employee who's taking the lead on serving justice-involved folks and is really developing that shared vocabulary just on the one-on-one level rather than at multi-agency trainings, and really doing some self-education about what things like criminal risk and criminogenic needs mean. Another challenge we wanted to talk about is one that is important for both criminal justice and county behavioral health providers to be aware of, and that's the need to make sure that the treatment you're providing and the courtrooms that you're running are culturally competent. And so Judge Flores shared with us a really personal story about how he came to realize the importance of culturally competent care. And I want to share that with our webinar audience today.
Now, let me share with you something real personal to me, because I do a lot of public speaking about collaborative courts and collaborative justice. And I talk about the mental health courts, and my own mother was mentally ill. My late mother, Francisca. And she had a very serious psychotic episode when I was in law school. And so this was back in the late 70s, 1977, 78, 79. And I tell people that, none of us in the family, Latinos, could understand how tortured she was, how tortured anybody suffering from mental illness was. And being Latino, we responded, me and my dad, my brother, and the whole family, we were mad at her. We would tell her things like, Mom, you're really embarrassing us. And not only were we not sensitive to her, but the mental health department at that time was not culturally proficient. My mother was an English speaker, a bilingual person, and very brilliant woman. However, she was ill, and there were no cultural components reflecting her individual background. There was no Latino health professionals basically back then, and the treatment that she received was not up to snuff. But we didn't know that. And they treated her like they treated so many people back then. They over-medicated her. She was basically a vegetable with all the methods they gave her. And I, for one, knew in reviewing my own history with my mother that I was mean to her. I was cruel. This is long before I became a lawyer, long before I became a judge. And she went on to find her own path to recovery through her own faith, her own spiritual awakening. And she forgave us. She forgave me. She forgave all of us for being cruel. She was able to get off, the medication. But I never forgave myself. And so I tell people, I was really kind of down on myself, and then the good Lord put his hand on my shoulder one day and said, Rogelio, you were mean to your mother when she needed you the most, and your penance is I'm going to send you 200 more just like her, and you're going to run a mental health court. I guess that's how this all happened, because and it was the greatest challenge of my life, to deal with people whose lives were falling apart as a result of being caught up in the criminal justice system. And I made it a point when I was assigned this duty to make sure that we were culturally proficient, that we were humane, that we were not draconian, and that we looked for solutions, including having input from the patients themselves, the defendants, as to how to give them better and to respect them. More than anything else, to give them respect.
So Judge Flores talked about a lot there, but one of the things he talked about was the importance of culturally competent care. And, one thing that wasn't a barrier for his mother was language, but that can be a barrier for different folks who are going to be in your courtroom, both Spanish speakers and then people who speak more difficult to serve languages. For example, folks who are maybe proficient or somewhat comfortable in Spanish, but their native language and the language they feel most comfortable in is an indigenous Mexican language, for example. And that was one example Judge Flores gave in a different part of his interview. You want to think about, communication barriers for people based on disability. You want to think about LGBT status, particularly if you're using faith-based providers who may be a really good fit for some folks, but may be alienating for people who've had negative experiences in the past. You want to think about immigration status, particularly if that affects funding streams and eligibility. And you also want to think about being gender responsive. So we've heard the example of if you have a veterans treatment court and you have a woman in the court who experienced sexual trauma while they're in the military, they may not feel as comfortable in a predominantly male setting. So you want to make sure that you're being attuned to all those needs. And that's a challenge for treatment and for criminal justice to assure that treatment providers you're utilizing aren't leaving anyone out. So the last challenge we wanted to address is sharing information, and this is often considered a barrier because of HIPAA and other privacy laws, but when we talk to our experts and our contributors, they found this to be often an overstated or exaggerated barrier, and they talked about how it's fairly easy to get a complete release of information, make sure it includes all the people you're going to be sharing information in, list all those players in your treatment team, and just have that becoming part of the routine. Judge Flores talked about practices for sharing information with the court and sharing the more private information or more sensitive information in staffing sessions in chambers before open court, and then not sharing that private information in open court. Nate Summers talked about reminding you all that when you have a new program, you're going to need a new release of information, but again, that's fairly easy to accomplish when you're in that routine. And Dr. Hobson talked about what they do in Plumas County to make sure that they can effectively share information between county behavioral health and jail medical staff, particularly because this may be a situation in many counties where the county behavioral health is on an electronic record system, whereas jail medical is still using paper files. And so some of the workarounds are really common sense, straightforward approaches. So in Plumas, they print out the electronic case county behavioral health file to provide it to the jail so there are no information gaps. And when someone enters county behavioral health, they make sure to get in the release of information or release to the jail so that they can coordinate if someone becomes incarcerated. And again, he described that as not a significant barrier. So then we've sort of addressed some of the most commonly expressed challenges, and we want to talk about what's working. So one thing that we heard over and over again that's working is if you create personal relationships between the criminal justice partners and the behavioral health partners. So in Santa Barbara, Dr. Cleghorn and Tracy McCouga talked about getting coffee together to problem solve. Cynthia Garcia talked about how in Solano she's on the opioid safety coalition with her behavioral health counterparts, and they went to a training in Southern California on medically assisted treatment. There, they're showing commitment to a common mission. They're developing shared expertise and shared vocabulary. And then she also talked about sort of just the experience of traveling and eating meals with someone on a trip, that builds relationship and builds commitment to those shared missions. And then we talked with Tony Tullis and Judge Manley about the dinners that happen monthly in Santa Clara, and I'll let them describe those.
We had Tony couldn't make it because of an emergency, but we just had our dinner 2 days ago. So we meet once a month, usually, sometimes more. And it's basically the deputy county executive and Tony and myself, and we go over a list of issues. They're usually issues I bring up about things that don't seem to be working in the court or that we're having challenges with. And we work through them and resolve them, and then we spend a lot of time on new ideas.
This is going out widely. I feel very fortunate because I had heard a lot about Judge Stephen Manley from one of my director colleagues, who's also a very dear friend and really very much a forensic mental health person. And she had told me all about Judge Manley, and my team in Alameda had heard all about Judge Manley. So when we started meeting, it was entertaining, educational, and productive, and it remains that way. So I think the judge has been doing this and is really at the lead in California and probably nationally on trying to get people the services they need out of court, really work with people in a way that is compelling and authentic, and then get them into the services they need. So, and with individuals that for many years nobody else would want to take care of.
And so one of the reasons that those personal relationships are important is we heard over and over again, that it's really important to build trust between the justice partners and the treatment providers, and to learn to trust the expertise of your partners on the other side of the house. And so Tracy McCouga talked about how that can be challenging and what she's learning.
One of the pain points, of course, is that even though we are collaborative and need to be collaborative, we both have different roles in the system, meaning that my lawyers have to advocate on the criminal side of the case, and we're in the social worker side or the collaborative side of, we're going to get this person these services with BeWell. Sometimes there's walls there that we can't cross, obviously, for ethical reasons. Also, what Alice and her team believes is in the best interest of the client. Sometimes we don't believe that is in the best interest of the client. And so we sort of hit that, like that wall between us. And I think it's an area for greater improvement. And I think it comes with building greater trust, meaning, for example, when Alice's group advocates for an outpatient option, and we are afraid that an outpatient option may not be the best for the client, that the client needs more intensive services, my lawyers have to learn to, although they have to advocate, they also have to learn to defer to the professional on that, because we're not psychiatrists, we're not psychologists.
So another thing we heard and we wanted to share, you'll notice that the 3 judges that we have asked to speak in this webinar are all collaborative court judges, and we learned that you can build really strong partnerships between treatment and the court in the collaborative courts, and then you want to leverage those partnerships to be able to do things countywide, not just for the participants in your collaborative court. And so Judge Manley talks about this in this clip.
From a judge's perspective, I think what you need to do is simply reach out and go to behavioral health rather than wait for everyone to come to you. I was totally frustrated years ago, and the basis of my frustration was I was expecting things to happen that were not happening, and the reason they weren't happening is they couldn't happen. We didn't have the staff. We didn't have the doctors. We didn't have any kind of relationship with behavioral health that we could build on. And so I found that if you go directly to them and work with them and try to help them in what they're trying to do, it ends up with a much better system, because you learn. We as judges don't know what the answer is in treatment. We don't know what we should be doing with the defendant other than trying to help him get into or her get into mental health treatment and stay in it. And these issues come up and they lead to frustration many times. And to me, the most important thing is that the judges take the leadership in starting collaboration with their partners, that the judges go to the county executive and go to the director of behavioral health and say, we want to work with you.
So another thing we heard that is really important is to be responsive to the needs of your partners. And one of the ways that we saw that happening on a really small level, but we thought was really important to share, was in this description of how Emily Bell with Special Services for Groups develops report templates to use for reporting to the court about treatment. And so she described how that works.
So I think usually with Department 95 with Judge Bianca, when we started doing the MIS cases, we showed a report that we were using for a different judge, and then he showed us a report that he's used to that speaks a little bit more to mental health, because he's in a mental health court, obviously. So we kind of combined the 2 forms and then agreed on a format. Like, he wanted the medications included, he wanted specific language about this, and so when we started, we had initiated that conversation about, this is what we use, what do you want to see, what would you tweak? And then over time there were some changes. Like, he would say, I want to see more about discharge planning when people are finishing, and so then we would tweak it, and then the ODR team created a policies and procedures based on those court reports so that everybody's following the same report format. But yeah, it's usually a conversation that we initiate in the beginning to make sure, because again, different courts have pretty different reporting that they want to see. So we usually leave it up to the judge to tell us what they want to hear, and really just make sure we're hitting on that every report.
Another example we heard of treatment really responding to the law enforcement or justice partner needs was this example in Santa Clara. We've heard as we work with criminal justice and behavioral health partners about the AB 1810 program, this question of divert to what. And at the bottom of the screen, you can see the sequential intercept model, which many of you are familiar with, but it basically talks about the different intercepts as someone's becoming more and more involved in the criminal justice system, at which they could be diverted to treatment or engaged in treatment. And so we're talking about here how to intercept and divert people before they get into jail or before they even get an arrest. And Tony talks about how she was able to, or how they're working on planning on responding to that need from law enforcement.
We are planning to open, design, and we've got a meeting about this next week, an urgent care center that would be in the same area as the sobering center and all the pre-trial diversion work. And the number one thing that law enforcement has asked us is, could we have a place that would be easy to drop somebody off if we know they don't need a 5150 and they're not going to custody, and we're working with the clinical team saying really what they need is services. So it would be exactly as you both describe, those really comfortable recliner chairs. We'd like to have showers, food, clothing available, and then the intent of this would be when people come in, if they come in at nighttime, they could stay there till the morning, where we would attach a care coordination team to try to get them connected to services. And so that it would be a place for the police to drop them off. It would be much better for people to be within an urgent care setting than to be sitting in EPS if they don't need to be in EPS.
So sometimes you're not able to divert before jail. And so we talked with some of our partners about using jail as an opportunity to engage people in services if jail was unable to be avoided. And so Dr. Hobson explained how that can happen and how they're doing that in Plumas.
So what we've tried to do, or what we have done, actually, is we've built a continuum of care inside the jail that one could get in the community, meaning they could start treatment, behavioral health treatment, while they're incarcerated. So we complete all the opening paperwork as though we were able to bill Medi-Cal, which we can't in the jail because it's a lockout. So we complete all the opening paperwork, we write the assessment, the treatment plan, and begin services, whether that be individual counseling, group counseling, or medication support.
And this is how Nate Summers describes the correctional health involvement in the jail.
An example would be somebody who we release to a program, they leave the program the first day, they go in warrant status, they get picked up, they go back to jail, they go to another program, and this cycle of like 5, 6, 7 times in a month, right, of being released and then going to a program. At some point you have to ask yourself, obviously they need the program, but they're not willing to take it. While they're in custody, we don't use the custody time to extend their stay to see the clinician, but if somebody that is qualified can go visit them while in custody and say, hey, this guy might have an underlying mental health issue, something we would miss because we're counselors, we're drug and alcohol people, and it's not really severe to the point where it's like profound where you can't not notice it. They have the ability to get in there, and then they catch them in a very vulnerable time because they're just right in the jail. They have a really vested interest in being honest with them because that could help them get out of jail. And so I find that has been humongous for us.
Another practice we heard being really successful is being trauma-informed in terms of how you're running your courtrooms. And so this is the example of the gender-responsive courtroom. In San Joaquin, Jenny Rodriguez-Moore described how they were seeing more and more women in their DUI court, and that they were finding that many of the women, their underlying substance use or alcohol use was intertwined with a trauma, and predominantly sexual trauma. And they found that the female participants in their court were more comfortable being in an all-female calendar, and so they developed 2 tracks for the DUI courts, and they've been getting data about the efficacy about that, and then also getting participant feedback, and they've found that splitting up and being more gender responsive really meets those trauma needs of the women who are dealing with trauma underlying their the reason that they're offending. And so that's one example of being trauma informed, but there are obviously countless. Another thing we heard that is really effective is streamlining the referral process by having assessors and screeners in court and having a bunch of stakeholders on particular calendars that you can refer people to so you can quickly screen, assess, refer in place. And Nate Summers talks about how they do that in his court.
And then, so we have all the stakeholders there. It's only 1 hour of the day. So correctional help is there, behavioral help is there. Each case manager from each of the programs, all the different AB 109s, the drug courts, the DUI courts, they all show up there. Once their warrant is issued, that's where they come back, okay? And so everybody who needs to be there is there. So the decision can be made then. You know, the research says 4 to 6 days is all you want to do for a sanction, right? But if they get arrested on a Friday and then they get arraigned on a Monday, right? And the person that their case manager isn't going to be there till Wednesday, so then they come back Wednesday. If you say you're going to do a plan, by the time that plan kicks in, you've already gotten 7 to 10 days just because of the machine of the bureaucracy. But by having this hub and having all the stakeholders there, we have eliminated that. So we have improved our sanction time tremendously.
And there are also smaller ways to do this. So Cynthia Garcia talked about their court having a gap between referral and onboarding into a program, and so they talked with the treatment provider and figured out exactly when during the week they meet to discuss new applicants so they could coordinate with that timeline and at least shrink some of the delay between referral and placement. We also wanted to talk a little bit about what we learned about coordinating supervision and treatment. We spoke with Chief Jenkins about 2 innovations that he started in his county, so we'll let him talk about one of those.
Created a community resource directory, which was an inventory of providers in San Diego County that probation officers could use when they're trying to match persons on probation to providers to address certain criminogenic needs. So in creating that resource directory, not only do we need to understand each other's language, but we needed to work together to monitor the progress of individuals that we might have referred to a certain provider, so that my goal was that the person on supervision would see that they were working with a team, the probation officer and the provider, towards their ultimate success.
And Chief Jenkins also created a new position, a director of treatment within the probation department, and hired someone with a clinical treatment background, and he talks a little bit about that and why he did that in this next clip.
I had the idea that I wanted to create a position of a treatment director in the probation department, and whose task would be to oversee the delivery of treatment, clinical and even non-clinical services that the department would provide to the probation population we were responsible for, and importantly, help to build bridges between the treatment community, again, behavioral health providers, county providers, and local community providers, and probation staff.
And so following up on supervision, one thing we learned that we wanted to share with you from Jenny Rodriguez-Moore from San Joaquin is that they were noticing really high revocation rates in their courts, in their collaborative court, for people that had already finished a residential drug treatment program or other treatment program, and then sort of had problems after completing that program. And when they looked at the data, they saw that they were having better success with people who, when they had their first, missed appointment or missed test, and they were able to quickly get them back to court, than they were with people who had a missed test or missed appointment and then were in warrant status for a longer period of time and were able to deteriorate further. And so what they did based on that data was they developed a relationship with the Stockton police, and they assigned officers specifically to execute warrants for people who are on probation and had those technical violations, so that they could bring people directly from arrest right into the court and get them screened, assessed, and referred and placed in treatment really quickly, so they weren't able to get to the state where they were so deteriorated that it was difficult to engage them in treatment again. And so that was one example we saw of the collaboration working really quickly to get people back into services. Another thing that Jenny shared with us, and you may have heard in some of my descriptions of my interview with her, is the importance of data more generally. She talked about, and her role is to be an analyst, analyzing data to figure out what a need is in your community or your court, then finding a grant opportunity to meet that need, applying for the grant, using that data to support your application, obtaining the grant, starting the program, collecting data to demonstrate the efficacy of the program, and then also analyzing that data to see where there are gaps in what you're providing. And Jenny also wanted me to share an important thought, which is if you as the court are not eligible for the grant, help your community partners apply for the grant, because an additional treatment bed, more housing in your community, that supports the work of the court as well. Before we get to the questions and answers, wanted to just make sure everyone knows that we now have a Behavioral Health Education Series webpage on the CalCourts website. Here is the link, and we have information about future programming, the recordings from the past webinars, and then also you can see at the bottom resources, including some of the ones that have been referred to here. So we're adding information about ASAM and links to that on that resource page. We also wanted to make sure that folks know that we are going to be hosting, or not hosting, but working on developing 2 regional roundtable events about AB 1810 implementation. Those are designed for court coordinators and judges, so not everyone is able to go to those, but we hope that the judges and court coordinators who are able will come to the Northern and Southern region roundtable events. And we're basically taking the Behavioral Health Education Series on the road. You can see some of our presenters for that program. So now we're going to go to the question and answer portion, and these are the folks that we believe we have on the line. One of the first questions that we got was, are all judges trained on working with people with substance use or mental health issues?
This is Judge Blavianos. I could try. Unless you're assigned, you don't get any specific training on, substance abuse, mental health, and working with substance abuse, mental health clients. They do get a session from Judge Manley, at the Judges College, but there's not a lot of regular training. Am I right, Steve?
You are right.
And so that's one of the gaps we're trying to meet with this Behavioral Health Education Series, but that's a great question. So here's another question for maybe someone on the treatment side. So we had a question about whether treatment providers typically consider goals such as reducing criminal recidivism as part of their treatment plan.
This is Mac. I'm not a treatment provider, but I have an opinion on that, and I'll try and be concise. And I think that when treatment providers focus on whatever their goals are from a clinical perspective, if those goals are focused on trying to change some of the behavior that is related to what brought the person into the criminal justice system, a reduction of recidivism may be a de facto product of that. So I don't know necessarily that treatment providers themselves need to have in their plans a specific reduction of recidivism as a treatment plan goal. Again, just restating, addressing some of those behaviors, and I'm speaking broadly now, and it's a point I made earlier during the interview, as those behaviors are changed, reduction of recidivism easily is the product of that.
Thank you. And we also, actually, Dr. Hobson did respond to that question in an email, so I'll just read his response. He says that this might be part of the language issue between the two systems, and that county behavioral health is required to address the functional impairments in the treatment plan, and a functional impairment can contribute to the behaviors that result in criminal behavior. And so he also mentions that it's very helpful when behavioral health provider can receive the risk assessment from the criminal justice system, so they are then better informed in creating the treatment plan. So we have a question specifically for Judge Flavianos, who I think mentioned at some point in one of the clips that the research says flash incarceration should only be for 4 to 6 days, and asked why that is. We are going to have a slide on that after the Q&A, but if you could maybe give a brief answer for that, Judge Flavianos.
They studied more than 100 drug courts nationwide, more than 1,000 participants to determine what that flash incarceration did, the effect of it, and on either increasing or decreasing recidivism. If you go from between 2 to 6 days in jail, you get about a 10 to 15% reduction in recidivism. When the minute you get to day 7, it's about a 40% increase in recidivism, and then it gets worse the longer you keep them in. I didn't believe it when I first saw the slide, but I decided since they were good researchers, I'd try the practice, and then it turned out to be exactly true. So my answer is because the researchers say so.
So here's a question that I think maybe is a good question for a lot of you folks, but how are county jails successfully linking inmates released from custody to behavioral health services in the community?
I mean, I'll just tell you what we do is we have behavioral health in the jail now, and therefore custody mental health that's responsible for all the mentally ill offenders in the jail is directly part of behavioral health, and they interface and try to connect people. But the issue to me is not connecting people. The issue is you can't control the release date. So if you're going to connect someone and the judge orders the person released tomorrow, you got to make sure the person has the medications, and you've got exactly 1 day to do it, or less. If the judge is like, if I order somebody released tonight because his time is up, or a judge modifies the sentence. So I think that is the real problem in discharge planning. If you could predict, like with 1178, this person's going to be in jail for 8 months, then you can plan that they're going to get out in 8 months and they're not going to get out sooner. But there are a whole lot of people that go in and out of the jail so fast that you can never really get them connected unless you have someone in the jail to do it. So, I mean, what we're doing is building what we would call a diversion center right across the street from the jail where we already have 16 beds, and we're going to put more. I mean, the county's doing all of this so that we can move people from the jail to there. From there, triage them into the right level of care. I mean, that's the plan. Whether, right now there are 16 beds, but we haven't gotten to the point of really making this work.
This is Judge Blavianos. I could add, we aren't as lucky as Judge Manley in terms of having behavioral health inside the jail at this point to do that coordination. But the agency that does work with them in jail has worked with the Sheriff's Department, so we can have individuals delivered directly to behavioral health. So the sheriff actually physically transports them over to behavioral health. So it's a warm handoff with level of care. That's one thing that our county agencies put together to be able to try to transition that. I agree with Judge Manley completely in that trying to control the date is a little bit difficult. I do have one advantage in that I have the correctional health individuals in my courtroom a lot of times, so they can work on the meds and we can plan the date a little bit, but it is tough.
We had another question, the clip that Dr. Hobson contributed, where he talked about developing a continuum of care in the jail, and one of our participants was wondering how many counties are working on building up something like that. And so I don't know if people wanted to share. Maybe if we could hear from Santa Barbara about how they're coordinating with jail.
We're actually working with the jail in the context of our Justice Alliance team, which is staff that have been funded through the Mental Health Services Act. They work closely in the courts and in the jails with clients who have mental health issues and try to help create a picture of what's going on with the client so that can help in their criminal justice proceedings. So they'll actually go in the jail and work with clients and also work closely with jail health. Since we're not the jail provider, it's another group that used to be called CFMG and is now known as WellPath. So we try to form those collaborations and work that way with folks in the jail.
So then we had another question about whether or how treatment providers are trained on working with the criminal justice system. So maybe someone on the treatment side, either Dr. Hobson or Dr. Cleghorn, could maybe talk about that.
Hi, this is Emily. So for us, in LA County at least, there are quite a few trainings that are sponsored by the Department of Mental Health for mental health providers. I've done some of them myself, so they do usually have a training plan for the year, and they do include some trainings like Criminal Justice 101, just basic overview of the different types of supervision and some of the different things we should be aware of in terms of working with sex offenders and the different requirements of supervision. And then they've added more and more with AB 109 starting here and expanding some of the forensic work in the county. They've been adding more and more training specifically for the justice-involved population.
Great. Thank you, Emily. So I'll give it another minute. I think that's most of the questions that we've gotten, so I'll give it a minute and then we'll move on to our bonus material.
Can I add to that last question about training treatment providers? This is Mac.
Of course, Chief Jenkins.
Well, just again, because I think it's so important. I think it's the crux of, generally what the webinar is about. And some of what we did do in San Diego, I had an opportunity to co-present and do a number of trainings. And the substance of that training was sharing with some of the treatment providers a lot of the research material that probation departments now give to probation officers around criminogenic risk and need and effective interventions. I see that, and I think somebody mentioned that it was useful to have access to probation pre-sentence reports. And I think that's useful, but it also involves a little bit of training in terms of interpreting and understanding what those reports say and how to get the best use out of them. And I know in my experience in doing some of those trainings, candidly, some of the providers that we were working with did not have a good understanding of even the term criminogenic need and how that was related to or could be applied in a case plan. So my point is just I'm trying to just endorse that I think that's a must-do to build bridges between criminal justice and behavioral health, that those trainings have to occur and have been done with good success. And it's not an effort to make a clinician a probation officer, nor vice versa, but it is absolutely an effort to just share information about the application of some of the research around what has been effective with criminal justice populations.
I'd like to speak on that just for a moment. Our post-secondary institutions, in my opinion, do not do a good job preparing prospective students in the marriage and family therapy track or the MSW track on working with this population. I think a lot more can be done on educating future therapists on understanding criminogenic risk, best practices for working with this population, greater emphasis on trauma. We see so much trauma in this population and it's generational, and it goes back a long time. And I think greater investment needs to be made in our post-secondary institutions.
I think those were all the questions we got. So I wanted to thank the contributors generally, and particularly those who were able to participate in the question and answer session. I think we're going to move on to the bonus material now. But again, I really want to thank everyone who contributed. Arlie and I learned so much, and we hope that our webinar audience has been able to learn so much as well. And some of the questions we got, actually, we're going to discuss in greater detail in the bonus material. So if you can stay, which we know that particularly judges who have a calendar at 1:30 can't, feel free to stay on the line or to watch that content recorded on your own time. Thank you again.